Great. We are rolling on March 17th at UCLA, where it's a beautiful day. The sunshine is shining, as it usually does. And we're here to debate the question, a rather unique question and timely one. This House would bring back Judge Scalia. This House should bring back Justice Anton Scalia to the Supreme Court. And speaking in favor of this proposition, for a speech not to exceed 7 minutes in length, is Robin Wells.
Okay, so today I'm going to speak in the affirmative on the proposition of bringing back Justice Scalia to the Supreme Court. So what's the problem? The problem is liberal justices are undermining the U.S. Constitution's original intent. And what I mean by this is that the Supreme Court liberal justices exercise liberal speculation about the drafter's original intent of the meaning of the words in the Constitution. This is from the University of Baltimore Law. In recent decades, liberal Supreme Court justices have applied figurative interpretations of the U.S. Constitution laws to determine national policies. Furthermore, they've also, left to their own devices, have used personal interpretations requiring what they call the reasonable person to shape political decisions in court cases that affect national policies as well. Justice Scalia, however, presents another side of this argument. He suggests that the liberal justices attempt to, instead of applying their own personal opinions, use constitutional idealism of self-government and respect that and honor it, which apparently he believes they have not done this. So in many of his writings, Justice Scalia has called for people's right to self-government through citizenry, voting on laws and policies, not decisions rendered by unelected judges. Scalia voiced concern about these unelected judges deciding the policy for the entire society and overruling state laws. Now, other things that Justice Scalia has to offer in terms of addressing this issue is he's transformed the Supreme Court's legal debate. Justice Scalia, his views on textualism and originalism, and his role as a judge in our society has transformed the terms of legal debate in this country. This is per Business Insider. Scalia's greatest influence...
Let me interrupt you because you're making the same mistake over and over
I'm doing
again.
it again?
You're supposed to give the...
Stop it.
You're supposed to give the date of your source as well as the source.
Oh, okay, sorry.
Business Leader in 2014 or 2016.
2016, okay,
Thank
so
you.
sorry. So do you want me to start over?
No, just starting out, but give dates from now on.
Okay.
Okay, go on.
Okay. So Scalia's greatest influence is liberal justices and scholars now reference constitutional text and history in order to insist that the conservative justices are actually ignoring the original content of the Constitution, which is ironic. This is Business Insider, February 2016. And Professor Adam Winkler of UCLA Law states that Scalia's influence has helped to popularize originalism's reading of the Constitution, which many today view as the leading way to interpret the Constitution. And Harvard Law professor Alan Dershowitz states that the most fundamental contribution of Justice Scalia's has been his methodology, his way of looking at originalism, his way of looking at the intent of the original drafters of our Constitution, and his way of disregarding precedent. Business Insider, 2016.
4 left.
Okay. Justice Scalia's impact on the U.S. legal framework has been incalculable, as Mr. Goldstein writes in Politico. He says that substantially he has reframed discussions of constitutional, statutory, and administrative laws. He is a justice who has added the most important impact over our years in how we think and talk about law, says Justice Kagan, who's a prior dean of Harvard Law as well, from Politico 2016. Now, Justice Scalia has really reinforced as well the rule of law, which he believes many of the current liberal justices have somehow grayed the area of this area of law. And instead of following the well-principled, clear written rules, regulations, and legal principles, they have created a shade based on their own interpretation and opinions, which he objects to. How big is this problem? This problem is huge because without Justice Scalia, the textualism and his originalism voice, the following amendments, the First Amendment, Second Amendment, Fourth Amendment, and Sixth Amendment rights could have been severely undermined in the following cases that I'm about to mention to you. Justice Scalia, on a First Amendment case, in Brown versus Entertainment Merchants Association, fought for the right for First Amendment rights for rights to minors to play video games. He argued that if you were going to say that games were harmful and that they triggered violence in children, then you'd also have to do away with fairy tales, television shows, movies, playing cowboys and Indians, and that's just the beginning. So, and I think that's an excellent point. When he got to the Second Amendment cases that I'm going to reference now, which is the District of Columbia versus Heller, he protected and defended the Second Amendment right to bear arms. And in this case, he researched through, again, the textualism and originalism, the original intent of the word militia. He determined that, once again, this did not include or was not exclusive to the military, so therefore a private person could own a gun. Justice Scalia, on the Sixth Amendment, there were 3 cases, and Crawford versus Washington, he challenged the Confrontation Clause of the Sixth Amendment, protecting, again, a citizen's right to address their accuser. And in this watershed case, his jurisprudence led to a ruling against the police, who were able to submit some sort of witnessing through the wife without having her appear in court. In Ohio versus Roberts, he was key in overturning this precedent case, and in contrast, Justice Roberts had applied the reliability test, which originally created Ohio versus Roberts, saying that the police could actually submit, or even lawyers could submit evidence without having the person present, who's the accuser. Justice Scalia also, in the Fourth Amendment cases of United States versus Jones, Kelo, and Florida versus Jardin, he objected to the police power and the government intrusion of the Fourth Amendment and the rights of citizens in their home and in their cars not to have illegal search and seizure used against them. And in all of these cases, he won. He won over all the other justices, and the votes were 5-4. So that shows his importance in terms of the Supreme Court.
30 seconds.
Okay, why do we have this problem? We have this problem because loose interpretations and many of the liberal justices distorting the intent of the original Constitution. What's the solution? The solution is to bring Justice Scalia back so that he can be there and be a voice of reason and rationale on originalism and textualism. Will the solution work? Of course it'll work. He has a 30-year track record of proving his discourse and decisions, and it also benefits contemporary society who currently are dealing with their surveillance issues. Moving forward here, the advantages, I've mentioned all of these about his contributions, his originalism, and then the disadvantages, I believe...
You don't have to mention them, that's his job.
There really aren't. And on balance, the advantages is basically outweighed by any negatives of Scalia's votes in the Supreme Court decisions. In conclusion, this House stands open for questions.
Thank you.
Sorry.
Give me a moment to jot down the note or so. Oh, I got to adjust the camera. You're a little taller than Robin.
I'll have to get higher heels next time.
Okay.
No, bachelor of your case is that he's popularized originalism. Now I want to ask you, can you actually give us an inherent benefit to having originalism as the framework used to interpret the Constitution?
Of course I can. Just as I had said here in the case of the Fourth Amendment. I think that in the Fourth Amendment, where we have, hold on one second. I'm sorry, not the Fourth, the Sixth Amendment, where we have the police who've been using evidence and presenting it in cases, but not allowing the person who's being accused to confront their accuser. It doesn't give them the opportunity to defend themselves either, or to cross-examine.
Well, that doesn't actually address the question of originalism, but actually let's go on to the issue of accusers' rights. Now,
Stare at me, you're
Okay.
trying to
how did
persuade
Justice
me.
Scalia feel when you talk about the rights of those accused of crimes like terrorism, like what we saw in Guantanamo Bay?
Well, I think that his say, originalism is to look at the historic meaning, the original drafters' intent, and I don't think there were any terrorists around back then, so it probably makes it difficult.
So, if we're going back to the idea, the actual question I asked in the beginning of originalism, let's ask, how many states were in the U.S. when the Constitution was drafted?
Was it 12?
2 left.
12.
Okay. How many people what was the population of the United States?
That I don't know.
What was the United States' position in the economy?
The United States, I would say we were just developing.
That's the thing. Isn't it true that the United States was a completely different country when the Constitution was drafted than what it is today? Isn't that the reason why we have a Bill of Rights?
Look at me.
Yes, it is, but I will say this, that the Constitution is very broad and it covers, it's meant to be this blanketed kind of umbrella so that it can grow and expand as contemporary issues arise. But that doesn't mean that you completely dispel things like the Second Amendment right to bear arms.
1 minute,
I don't think-
hand out of your pocket.
I don't think it was trying to dispel the Second Amendment, but if you're saying that it's this broad blanketed statement, then if you're interpreting it just as the broad statement, then doesn't that leave the decision of the Supreme Court Justice up to pure conjecture of whatever he's feeling that day? That's his originalist opinion, if it's this broad of a statement as you say it is?
Well, no, because I think we've come up with a lot of issues about First Amendment rights, and as I said before, we could definitely have said, oh, video games is bad for children, because contemporary
Sure.
people in society thought that way. But in fact, it's a First Amendment right for someone to be able to speak, to be able to play games, to write stories.
30
Sure,
seconds.
but I mean, we can give clear example of First Amendment rights where, yes, a video game you can play, but this doesn't actually...
They almost lost that.
This is a specific example, but we can give just as many
that's
counters to Justice
technology.
Scalia, right? Whereas he even tried to say that homosexual sex should be outlawed because people don't like it. We see just as many examples of Scalia where he may bar First Amendment rights as he does give them.
But
Does this not give the impression that Scalia is not actually driven by constitutional interpretation, but by his own emotional preferences for each case?
I don't think so. I think that, as you just pointed out, some of this is interpretive, and this is his interpretation of what he believes the original drafter's intent is. And I believe that he really does try, as I said, he has sided with liberals. Maybe, he's not perfect, he's human. He's made some decisions.
Tell me,
maybe there's some
it's
biases
me you're
applied.
trying to persuade.
But at the same time, I believe overall, as everything is outweighed, he has done a tremendous amount in making the other justices think about the Constitution's original intent, which is always important to kind of
Great.
touch base on that.
Okay, that's time. Thank you. Chair will now recognize the leader of the opposition for
I'm
a
like,
speech
what?
not to exceed 7 minutes in length. Okay, so now you come and sit down here.
Oh, sorry. I didn't know you had to do one. Okay.
Yeah.
So that means I need a resolution.
All right.
You want something to take notes on?
Oh, look at you.
Okay.
Now, Antonin Scalia said in 2009 that I'm not about to give this man who's captured in war a full jury trial. I mean, that's crazy. He thought that the rights of the accused are just crazy to give them due process if they aren't Americans, if they're accused of a crime. We think that's the epitome of Justice Scalia's flaws. Is he allows personal preference, what he thinks is crazy, to cloud his actual opinions of the original intent of the Constitution, which is to give justice to all people under this umbrella of the United States of America. Because of that, we affirm that we should not bring Justice Scalia back from the dead. Now, what's the problem? We don't agree with the problem brought up by the government. We think that that's a very jaded problem. We think that what the real problem is that the Supreme Court has been used by Justice Scalia in an attempt to proffer his own personal gains. And we see this problem has been big because, as she delightfully pointed out, he's been there for almost 30 years. We see he's been able in countless landmark decisions where we've seen that he has marred the Supreme Court with bad decision making because he's ruled on everything from affirmative action to the rights of Guantanamo Bay people to get habeas corpus trials, to try to criminalize homosexual intercourse. He's been there for this long, and he has plagued the court for that long. He has often been the sole dissenter in important decisions, for example, in Morrison v. Olson, Mistretta v. United States, and Russell v. Bush. Or is he the only person who does not actually rule with one side because he's the only person who's using his own personal opinion to actually dictate his opinion? And this leads us to the real issue of why do we have this problem. And we give you 3 reasons why Scalia specifically is bad for the Supreme Court and why him being gone is good. The first reason is that he's driven by his emotions rather than actual interpretation of the Constitution. The second is that he's going to justify his decision under the thinly veiled guise of originalism, which the government loves to talk about. And the third is that he gives unwarranted intrinsic value to the status quo, which inherently hinders progress. Let's go into the first reason why we have the problem. He was driven by his emotions. The job of a Supreme Court justice is not to let your opinions decide where the country goes.
Stay in the power stance.
That's what anyone
right
can do.
in your shoulders.
The job of a Supreme Court justice
Better.
is to make interpretations on the Constitution that will dictate the future of this country. Justice Scalia did not do that. I think the best way to illustrate this opinion, to illustrate him letting emotions drive him, is to give you 4 examples of when emotions did drive him, and how outrageous it really is to think that this man, who is 50 years old and is a Harvard law graduate, was saying these things in his opinions. Let's go to the first one. We talked about when discussing detainees' rights of people detained in Guantanamo Bay after the 9/11 attacks. In 2006, BBC reported him saying, "Give me a break. I had a son on the battlefield, and they were shooting at my son. I'm not about to give this man who was captured in war a full jury trial. That's crazy." That's what I allude to in my introduction. He thought, hey, this guy could have been shooting at my son. I'm not going to give him a fair trial. He thought that's okay. And we say that's absolutely outrageous, because the Supreme Court justice is not your job to say, do I like this person, do I not? It's your job to say, does this person deserve the rights that every other person in America has? And that's what you should be defending, if anything, as a Supreme Court justice. Don't buy into the rhetoric they give you as this is just liberal justices putting in their opinions. No, this is the act of real people giving their opinions, of actually interpreting the Constitution, not just saying, I'm going to go with my opinion, the Constitution is so vague, I'm just going to veil it with originalism. Second example. In his decisions, now mind you this man is a Harvard law graduate. He used the following terms to make his dissents. He called opinions argle-bargle, he called decisions pure applesauce, and he called decisions hookery-pokery.
I like hookery.
Okay? And we just see, if you even like these words, it shows a lack of respect for the opposite side. And we think this sets the precedent that when you let emotions run your opinions, what do? You take away the actual meaningful discourse we have, where you no longer respect their opinions, and you now are just throwing out vitriol like we see Donald Trump doing, right? He's just saying whatever he can to try to distract from the other side's actual opinions. We think that's a problem. Third example. In his sole dissent of Morrison v. Olson, which dealt with upholding the U.S. Independent Council, in 1988, he wrote a 30-page dissent of the decision. Right. And what did Co-Justice Harry Blackmun say? He said that it could have been cut down to 10 pages if Scalia omitted the screaming. That's the epitome of the decision. And even his dissent, 66% of his dissent was just his own emotions running. It's just him screaming at the audience, at the other justices to change their minds. That's not how we make a decision in this country. That's how the Supreme Court should work. That's how Justice Scalia worked, though. We think that's a problem. Fourth example, in his Lawrence v. Texas case, where he attempted to outlaw homosexual intercourse, this was his reasoning, okay, people? Just listen to this. Americans do not want persons who openly engage in homosexual conduct as partners in their business, as scoutmasters for their children, as teachers in their children's schools, or as boarders in their homes. I mean, the man just let a heckler's veto run his constitutional decision. He thought people don't like homosexuals, so why give them rights? Why let them have sex? We think this is absolutely outrageous. This is a critical example of why Scalia is not qualified to even be on the Supreme Court in the first place. With this, we lead to the second decision of why he's being able to make these decisions and why he hasn't been kicked out sooner, which is his guise of originalism, which the government loves. Now, in NPR in 2016, they defined originalism as basically the Constitution as what it meant when it was adopted. Okay, this is also what Scalia uses for his justification. Now, as they even say, as the government stated, right, This document was drafted 300 years ago by people in a completely different situation, by slave owners, for God's sakes, by people who had different intentions of what it means. And it doesn't mean the document's invalid because its original intentions are very important. But the document must be interpreted not by what its original intent, but how it can apply to the modern-day United States, a country that has changed. And that leads us to really the third reason, right? And that's the unwarranted intrinsic value in the status quo. It's easy to value the status quo, but the country has changed and it's ever-changing. That's why you must value the new, not the old. Now, his adherence to the original intent thwarted efforts at establishing progressive ideals. And they're not just liberal ideals, they're basic ideals that are just... They're basic ideals that are just progressive. For example, Daniel Ledlow, Northeastern law professor, said in 2016 that the consequence of his judicial philosophy was to enforce the status quo, and that it originally benefited particular groups and Justice Scalia adherence to original intent thwarted efforts and progress by historically disadvantaged groups. He principled approach to the Constitution interpretation. Others called it bigotry. Sorry for the bad thing. What does that mean? What he was really doing by using the original intent was enforcing the bigotry that we had in this country 300 years ago that may not be around today. That even if it is around today, that we don't want to be around today. By valuing the status quo like Scalia did, we enforce that bigotry, we enforce that hate, we enforce the systematic oppression that had been put onto people because that was the original intent. What's the solution? It's easy. Don't raise him from the dead. Don't bring Scalia back. He's already gone. I've given you plenty of advantages. The only disadvantage is what? Maybe we have some political gridlock, we're making a new candidate. But at least we'll have some justice in the court. The Supreme Court justice is there to guide our country. So if you want to ask me, it's really crazy. It's not giving an accused terrorist a fair trial. It's the fact that Justice Scalia was ever in the Supreme Court at all. Thank you.
How do you really feel? No?
Thank you. I now stand open for
cross-examination. Points of clarification.
I like the way you laid all your pages out, though.
Oh, thanks, yeah.
Instead of me like flipping through this whole thing. What a simple idea, and yet it really works. Okay. Here we go.
Okay, the chair recognizes the leader of the government for a cross-examination not to exceed 3 minutes in length. Begin.
Okay. So, Austin, while I appreciate your position about bringing Justice Scalia back to the Supreme Court, I do have to ask you a few questions and also argue a few points. When it comes to affirmative action, where in the Constitution, which amendment states that people, who the affirmative action would apply to, have a right over any other citizens?
Well, I don't think that's what affirmative action does, first of all. I reject that premise. But second of all, the issue is when we talk about amendments, right? The point of an amendment is not there until we put it in there. We make it a part of the amendments because the Constitution was flawed at the beginning. If we can go purely with original intent, then we wouldn't need amendments in the first place.
But currently, this affirmative action that you're referring to didn't trigger an amendment, correct?
That's true.
So then we're adding an interpretation to the Constitution that doesn't exist currently. Am I correct on that?
Well, no, I reject the hypothesis that I reject the idea that everything that's not an amendment is not an interpretation of the Constitution. We have plenty of Supreme Court justices that are interpretations of the Constitution.
Persuade me, Robin.
Amendments, right?
Well, I'm looking for language, though, in the Constitution, because we're talking about originalism and textualism, and we're critiquing Scalia's approach.
Well, if we really want to talk about affirmative action and how that's in the Constitution, the fact that all men are created equal is the founding words of this Constitution, but that systematic oppression, not just by people themselves, but by the government itself, has kept a certain population down, is enough to justify the fact that we must put certain people ahead, that we must give them the chance to come back from where the government has failed them. I think that is in the Constitution just enough. And I think that many people have seen that, even Scalia, closed-mindedly, could not.
Let's talk about this. If the language doesn't exist in the Constitution, and we're just strictly dealing with the Constitution, then I still think that I have a great point, that it isn't an amendment, and it's not in the Constitution itself, so therefore the argument that you're posing here, or proposing, is very weak, because what you're telling me is you don't like his version of reading the original intent of the drafters, and there's nothing in there about affirmative action.
Well,
So my question is, how do we argue? I'm going to move forward to something else now. I want to also ask you, where in the Constitution does it say that sodomy is also allowed?
Okay.
Like the Lawrence versus Texas.
I'll touch on the first point, okay? If you want to talk about constitutional basis, okay, anyone could just say what they think someone meant 300 years ago. That doesn't take a degree in law, that doesn't take an understanding of the Constitution. It takes a history decree.
Half.
The point of a justice is to interpret the Constitution to reflect the modern-day United States. To actually use that Constitution to determine how the country will go in the future and to make the proper advances. Not just say, what was life like in 1700s, okay? Not what did they want. Because, I mean, some of them may well have wanted slavery, right? I mean, that was a part of the Constitution. But that's not, we obviously agree that's wrong. We could even say that's not what they meant. But that was in there. And if we want to talk about the idea of where to justify sodomy, is I think the whole reason we have a Supreme Court is because not everything is explicitly stated. The point of the Constitution is to be vague and overly broad, as you conceded.
But
That's time.
the Constitution doesn't give us the right to have sex.
Thank you. Okay, and now it's time for 4 steps of refutation from the government, where you say, Austin said, I disagree, because, therefore. So now it's time for your
Can we go
rebuttal.
through?
Yes.
Yeah.
4 steps of refutation.
I'm not sure if I have that little guide. Okay, so
The guide of the 4 steps. Okay.
I got it.
quickly, because I didn't bring my notes. I
Here,
actually,
I got it. Chris, I got it.
Okay.
okay. My little cheat note.
Yeah. I just wrote it down for on a piece of paper.
Okay, well now she has it 2 places. Okay, Robin, I'm restarting the clock for a 3-minute rebuttal.
Okay. So Austin says that Justice Scalia he applies his own personal opinion, and he's very liberal about it. He's using it under the guise of originalism and textualism, but in fact, he's saying that he has a slant or a tilt, a particular bias. He's using that to exercise his authority, his position as a Supreme Court justice, and that there is injustice in that, as opposed to my version of what I believe, which is, I disagree with you because in the Constitution itself, I don't believe the points that you were making about affirmative action or sodomy even exist in the Constitution. I don't think there's any reference there whatsoever that would persuade me to believe that Justice Scalia was tilting it in a direction towards his bias. I believe that actually shows he's using originalism and textualism by reading the Constitution, looking at the original drafter's intent, and speaking on that point about the fact that everyone is created equal. So therefore, affirmative action isn't equal. It's favoring a certain group again. So we never stop that vicious cycle. It continues on and on and on. So therefore, what I say is that we should bring Scalia back because he also offers something that is very important in the court system and between the justices. He offers a different perspective. So, and I think there's always a balance between somebody who's a hardline liberal and someone who's maybe even hardline conservative, to bring them somewhere in the middle to bridge the gap. And he has done that on many cases. The amendment cases that I quoted, he brought liberals, Sotomayor, Kagan, and Ginsburg, to vote with him. So that in itself shows that he has some influence and that they respect his opinion, and they don't just go, these are very intelligent people. So therefore, that's what I believe. And I do believe that Justice Scalia has added a lot of flavor, dialogue, and jurisprudence to debate within the Supreme Court.
Okay, thank you. You had 45 seconds left, but that's fine.
Sorry.
Yeah. Someone needs an allergy pill.
As long as you're not sneezing on us, right?
Yes.
Now, I guess what this really has gone down to is, does Scalia add to the meaningful discourse that we have in today's judicial system? to answer this question, what I think we need to do is look at what the meaning of a justice is. What is their job on the Supreme Court? What I'm going to tell you is the point of the Supreme Court justice is not to read a document. It's not to tell us what they can read, because I think we can all do it. I think we all do in 8th grade. I think the point of a Supreme Court justice is to interpret the direction this country will go in for the direction's future. So they can be unafraid of the opinion of dissent of other people, and they can decide how a country progresses. And we think that Scalia does offer one of these traits. He's definitely not afraid to give his opinion. We give you that. But we think that he doesn't direct this country into the future, but he pulls us back into the past, and he doesn't even give us a reason for it. You can justify meaningful discourse as they want to do. They say, look, he gives a different perspective. And we think, yes, there are many different perspectives. We don't necessarily want them inside of our system. Why do you disagree with that? Because there are many things that are simply not good discourse. I mean, for example, hate speech is outlawed. It's not good discourse. Generally, the KKK is not great discourse in this country, right? We see there are lots of opinions that, yes, they're different, they aren't necessarily good. And I reject the notion that Scalia, just because he was an ultra-conservative, means he should have been on there. Because I think that people get nominated every year. We have different Supreme Court justices. We have some conservatives, we have some liberals. There's always the balance. It switches which direction the balance is in. Just because someone may be a conservative does not mean it's good that we have an extra conservative there. Therefore, I don't think we should bring Scalia back from the dead because of that. Originally, we just simply don't see much actual clash with the case, right? Now they continually say that, look, we need to use original, we need to go with the basic interpretation of the Constitution. But we don't get an intrinsic benefit to this. The only thing I can really see that we get out of this is we get stuck in the old dogmatic ways. Now, I gave you examples of where we saw Wedman from Northeastern say we get stuck with the status quo. And if you want to say the country was great as it was 300 years ago, then that's fine, and I value your opinion. I think that's discourse. What I don't think is valuable is saying that we need to stick in the old dogmatic ways that have kept systematically oppressed groups of people, allowing others to thrive, and having the guiding light of this country enforce that. I think Scalia represents more of a child than I think he does a justice. I think he lets his opinions get in the ways of decisions. He uses terms like argle-bargle, pure applesauce to describe decisions. He lets his emotions when describing people who may have attacked his son, that they don't deserve fair trial. I think he can't separate his emotions from the decisions he made. And I don't think that's unfounded. I think that's actually incredibly founded. I don't think that I, nor anyone here, can justify the reasoning of originalism, but rather I think it's obvious that it's just a thin guise for his actual opinions. If we want justice, we leave Scalia where he is, we let him rest peacefully, and we bring someone who can actually make valuable change in this country. For that reason, we urge a negative ballot.
Thank you.
You're very professional.
Okay, let's talk about what just went on and see if we can...
I let my nerves get the better of me. I'm like...
Okay, well, let's start with your own self-evaluation then. You felt your nerves got the better of you. What do you feel you could do about that in the future?
I'll use some breathing techniques to calm myself down.
Yeah. Practice more aloud with a live person listening to you. So you're used to doing it. Time your speech so that you're a little top heavy. You didn't get through the bottom parts of your speech. So where you had better stuff and you were kind of top heavy. I'm glad you skipped the definitions. They weren't needed.
I didn't think you needed that.
So that was fine.
I definitely
you tell us that the problem is liberal justices are undermining the U.S. Constitution's original intent. And so...
I guess I was referring to like precedent cases prior, you know what I'm saying? Like that he was so key to overturning in his next decision.
I think the point is there. I just don't think it was necessarily set properly.
Solid.
Right.
Well, yeah, I don't think the issue is the liberal justices, just that like...
Yeah.
Maybe in the past they've never took precedents.
And what I would have liked from you, Austin, to get a little ahead of the story would be to say, are liberal justices really undermining the U.S. Constitution's original intent, or are they doing what's necessary to keep our political system functioning?
Yeah, I guess they don't really do that.
And using original intent leads to dysfunctional constitution discourse. Yeah.
I actually had a different, you guys, what I actually had there for my, what's the problem?
Sure.
What I originally had said that, I think it was, let me see it first. I'll just tell you what I actually had. It was much more lengthy. I think I had said, hold on, I think it's over here. I think what I was referring to was like Scalia bringing back not only his aspect of the textualism and the original content, but how he had said what the problem was is that liberals were seeing it from one angle, he was seeing it from this other angle, so that there was this kind of banter. But it was too, like, I literally had like 2.5 cents, you know.
Right. Well, I mean, yeah. I guess the point is, it's just meaningful discourse, right? Like,
Right.
Yeah, I probably should have figured it away.
That's
I
the
was
point,
a little, my brain was a little fried. So then I go, I'm going to edit this back. But yeah, it did lose its meaning.
Also, in terms of your refutation, when she went through the...
Yeah, I kind of was light on it, to be honest.
Yeah, I would have liked to have heard stuff on the First Amendment, the Second Amendment, the Sixth Amendment,
the
Fourth Amendment.
I actually had some stuff, but then I kind of just turned to rhetoric instead, which is my fault.
Yeah.
Yeah. That's definitely right.
Yeah, so that would have been better there.
I only knew about the sodomy case because I had it in a German class.
Really?
Yeah.
I have it in an LGBT class. I'm like, wait a second, I didn't write that.
Yeah. It comes up a lot. There was we used to argue it years ago. There was a case called Hardwick versus Bauer. You know that one too, yeah. And we had a hell of a time arguing that case and trying to justify the Supreme Court's decision on that one too. It really was tough. I guess what I saw just overall in terms of take a line out of the 102 course of convincing vision. I wasn't convinced that originalism was the sine qua non, the absolute essential thing that's going to keep the
even though
court
I did the
operating.
Second Amendment,
You did it?
militia.
I didn't think there was. Yeah, I mean, I guess if you don't want to begin.
Yeah.
You made that, but I just didn't think there was an impact.
Right. I did.
So you said how originalism, like, okay, like, look, using originalism, we defended militias, we defended rights.
Yeah.
But you didn't extend to why do I really tell me explicitly why we care? I think that's really important. Especially here's the thing: if this doesn't happen, what's going to happen to you?
Right.
We lose this original intent. We lose the First Amendment. We lose the right to speak. We lose
the right to possess firearms.
Yeah.
And that sort of
Yeah.
thing.
So I think if you gave it a little more drawn impacts of this is why you need to care directly, I think it's a little bit more impactful. I think that's actually the hardest thing. Everyone always forgets to impact it out. But
And the Fourth Amendment,
I
the
do it all the
surveillance
time.
of the police, on your car, on your house.
Exactly. Yeah.
Okay. Whenever you have a cross-ex or a point of information in BP, you always want to have a goal.
Right.
A goal to make a point, to get a point of information across or something. And so I asked myself as I looked down your list, what I couldn't determine or see what your overarching goal was. I saw that you asked a lot of good questions, but I didn't see a sense of a goal that you were trying to get her on one big thing that was going to...
that's valid.
Okay, and it's good if you have a goal that kind of a strategy that will do that for you. I know it's difficult and it's kind of a minor point, but if you can look at the critic and not at your opponent, It's the same with when you go, if you're going to be a lawyer, you're going to be a lawyer or any other kind of thing. You're always, it's not the opponent, it's not the other lawyer that you're ever going to persuade. They'll never change their mind. It's the jury, it's the judge you want to keep your eyes on. Persuade. Just a little anecdotal piece of evidence. We had a final round at the Loyola tournament this last weekend, and one of our debaters said, "Oh my God, I was shocked when I saw who the judges were in the room when they stood up at the end." And I said, "Yeah, and I was more shocked that you didn't ask at the beginning, who are the judges, so you would know where to direct your eye contact and your arguments to."
Wait, who said that?
What do you do? He'll remain nameless, but he likes blue ties,
Okay.
and he spills things on the front of his shirts.
Uh-oh.
But
You mean red ties?
he likes red ties, and he spills things on his shirt. He dresses in gym shorts for out rounds. But anyway,
Jim Sharp.
but I said I was just as shocked that you didn't go into a room and say, who are the judges, who are the critics, so that you can direct your attention to them and know who to persuade. That's called audience analysis, and be able to read them when they're nodding. And because you can go for the chair is the king, but many times you can get lucky and have the wings flip the chairs, and it can work.
Wings flip the
I don't
chairs.
think in this what.
I'm like, wings flip the chairs, okay.
Yeah, I guess that's shop talk. I'm sorry.
That's okay.
Okay, Austin, on your refutation, I already mentioned
Yeah.
what?
Pure rhetoric.
Yeah, I mentioned that we needed more
No, I agree. Substantive refutation. Now.
substantive refutation, as well as some new matter as to, I guess, just some expert opinion that the court is going to function just finely without an originalist on the bench, even if we have, even if Donald Trump or
Crazy.
Kasich or Ted the Liar, or whatever his name is, even if they're elected,
When?
they're going to, appoint conservative people, not necessarily
Yeah.
these originalists.
Yeah.
So,
What's a strict construction?
construction. That's somebody that goes by the precedent,
Yeah.
and they believe that the precedent is pretty sacred, and it takes some real compelling societal information or interest to break it.
What's the term, like, let it stand? Like,
Stare decisis.
Stare
I guess.
decisis.
Yeah.
I was going to work on his dissents, because his dissents are so famous.
Yeah.
It was just so much.
Time. Yeah. Did you? I don't know how you approached researching this, but I would have first gone to the appreciations by his law clerks and people like that, and then I would have gone to the vitriol of the people that thought he was the biggest horse's ass to hit the court in 30 years. And then I would have sort of then tried to sort out in the middle some more reasoned discourse on it. Because when he first passed, I was shocked in looking at the articles that came down on the different websites, Drudge and so forth, that, we've lost the shining star on the hill, and then on other web Slate, they said, I'll go and throw dirt on his grave and piss on
Right.
his grave, and
A little bit of some anger.
very, so there are many people that, your friend, Charlie, took all his decisions and dissent very personally. As some people
really?
do. So, Gray,
He hated him?
Oh, he is Scalia. Yep, no case.
Yeah. So, on the refutation,
I don't know. I thought that the Fourth Amendment stuff about the surveillance and stuff was it's a pretty big deal to me.
Yeah,
yeah,
I think it is.
it is.
I just don't think. Yeah, I mean,
And considering we all think police are corrupt and even Black Lives Matter, that's
I didn't think you allocated enough time to it.
Yeah.
So I didn't even respond. I mean, if there was an audience here, I don't think they would have even picked it up,
I
to be
know.
honest.
Mm-hmm.
So I just kind of ignored it.
That's because I went too, I was like, yeah.
No, I didn't get a really good case, to be honest. I think it was a really solid case.
On the refutation, since I'll say this to you as Ringo Starr said, with peace and love, but if you had been able to come to class more often, you would have picked up more things of how people were doing the debates and how it was done and stuff. But the refutation was meant to be more along the lines of more specific arguments that were made, not broader ones. And so to do that, he said, I disagree because therefore you maybe would do that 5 times.
Oh, okay.
Yeah, which I didn't do either, to be fair.
You did it twice.
Yeah,
So
I just did overarching arguments.
Okay.
so but
So like each of my points, I should have done this. And
Like
then
one.
but in Austin could have very easily, had he been doing refutation
Well, yeah, I was
in a constructive speech, especially if he was going to do the refutation of Scalia's defense of the amendments to the Constitution, he could have said, okay, she first argues, what's your first
Amendment.
first argues the First Amendment and
Video
says this, I disagree because, and therefore let him keep staying in his grave. Next, she went on to the Fourth Amendment. See?
I gotcha.
And it makes for a crisper debate, and it makes for a
points.
clearer clash. You know where you are?
Just a tip for argument construction: you argue them all by example. And so, like, technically, for all of the amendment points, I could have just given another example, because especially Scalia's kind of he gives it contrary, and I would have destroyed the whole case. So just when you're speaking, try to give more of the link of to logically why it's bad.
Okay.
Not just examples as to why it's bad. Which, I mean, I did the same thing. I'm not saying my case wasn't great either, but just in general, it's better because arguing by example, it's a lot easier to refute.
Can you give me an example?
So you say he disrupts First Amendment rights. Look at video games. And you didn't give us any other reasons to why originalism would defend First Amendment, really.
Mm-hmm.
But I could just be okay, in this house, he took away free speech. Or I could make a case of the anti-sodomy thing is anti-free speech, anti-freedom of assembly, right? Whatever I could make. I mean,
throw something
because especially Scalia goes back and forth in all decisions because he's Scalia. So if you ever just pull that up, then the whole point's destroyed because your argument was made by the example, not by a logical principle that is backed up by the example.
Okay.
So yeah, you want to make it more by the principle rather than just
Citing a case.
And then
it's just to back up the logic.
And then Austin, for your final rebuttal, I would have liked you to have taken the page from BP and done more of a little opening like I like you did, and then 3 questions.
Oh, crystallizing, yeah.
Crystallizing 3.
I don't know if I was pertinent for this, but yeah, okay, that's true.
Well, I think it was more pertinent than the strict public policy analysis because, technically we're not going to resurrect him. He's with Ronnie and Nancy, in the hereafter now, and they're probably having their martinis and enjoying each other's company. Okay, well, we got it done. Thank you.
Yeah.
Sorry, I was a little rough on it.